Huh?
I realized what's making noises.
What?
The fucking turtles. I forgot we have turtles too. I just looked out there and saw the cave and I was like, yep, that's what I did. I thought I was hearing shit. Here we go.
Why?
You're quiet.
So?
You staying on the phone?
Yes, I am. This is a boring ass class. I have a quiz today. Not even all that serious. She's gonna babble and I'm just gonna sit here. 10 question, 12 minutes, time that, 12 plus 6 is 18. So I got 10 questions and 18 minutes to complete the quiz. See, I'm all dressed. Nothing to worry about.
I'm dressed. I'm always dressed.
I'm
cold.
I'm okay with you staying wrapped up though.
Why?
Because you let your cleavage show sometimes, and that's just a tease in its own.
I can't help it. They're fucking huge.
I like it. I can't help it.
I'm cold.
It's okay. Be cold.
I don't like being cold.
If I could be there to warm you up, I would.
Yo, me and Alicia, I'm telling you.
I mean, granted, if I was there today, we would just be cuddling and you'd be kissing me and you'd be cuddling on me and you'd be probably falling asleep. So, it's the unfortunate side, but it is life and
Life goes on.
there'll be other days.
These fucking cats are being weird.
In fact, if you want, I said, in fact, whenever your pain goes away and if we ever do get to have sex again, I won't penetrate you.
Yo, I don't want the fucking doctor penetrating me. But someone's making me go.
It's for your best.
What if I mentally break down?
I'm here. I'm not going anywhere. I'll tell you now, I know Danielle's off on Sunday. She'll probably work Monday. She'll be off. She'll work open Tuesday. She'll open Wednesday. I don't have a clue what the fuck she'll work the rest of the week. She'll definitely have at least a closing in there somewhere.
What if I mentally break down? Then what?
I'm going to be on the phone with you all fucking day. No, people are just coming into class. That's all I hear is the ding, the doorbell. There's only 4 of us, 5 of us.
How many's in the class?
A lot more than that.
Right, obviously.
Like 30 some, I think.
There's 5 out of 30.
So far. Class don't start till 11. There's another one. Oh, we're up to 6.
That's 3 minutes.
Okay, and I have people come into class at like 11:05, 11:10.
Yeah.
Teachers are talking and they're running their mouth.
So, good morning. I'll go ahead and get started. I wanted to make an announcement about an event for which you can get extra credit, and I'll be sending this out to the class. But today is actually Constitution Day, but we'll be celebrating it at IUP this coming Monday. And there's two events, and Constitution Day is the day in 1787 when the Constitution was signed and sent off to the states for ratification. But it was only something that we started commemorating or celebrating a lot kind of recently, a few years ago, because so in 2005, then West Virginia Senator Robert Byrd had seen a study that showed how little people in the US knew about the Constitution. And so he was a guy who carried a Constitution around in his pocket and thought people ought to know about their form of government. And so he put a little provision in an omnibus spending bill that said if any institutions of learning, and that meant K through 12 plus higher ed, if any of them receive federal dollars, then they have to commemorate Constitution Day in some way with activities that would help raise awareness of the Constitution. And so ever since then, universities and K through 12 are tasked with coming up with ways to do that. So we'll be celebrating on Monday, and if you attend either one of these, you can get extra credit, and I'll send out an email about this. But the first event will be from about noon to a little after 1 o'clock, and there's 3 ways that you can come be a part of this. It's a public reading of the Constitution. I'll divide the Constitution up into 100 parts, and 100 of us will read the Constitution. So historically, the way we did this was just in person out in the Oak Grove, right in front of the library. There'd be a podium and a microphone, and after, you know, Dr. Driscoll would join us and give a few comments, we'd start. And we start with the preamble, and we read all the way through the end of the 27th Amendment. But today, since there's the pandemic, I wanted to try to be more inclusive, but I didn't want the event to be completely virtual. So we'll be having people, you can come and line up, and we'll mark off X's that are 6 feet apart. But there's also 2 other ways to join, 2 virtual ways. You can be a part of you can participate in the reading by joining a Zoom link, and I'm working with an AV guy to, I'll be interspersing Zoom readers with the live readers, and then you'll read from Zoom, and it'll also be amplified out in the Oak Grove. To get the extra credit, you have to either come in person or read on Zoom, but we're also going to live stream it. You don't get extra credit for that. And those who read by either in person or on Zoom, you will get a pocket Constitution, a We the People at IUP t-shirt, and this one's kind of a special edition for those of you who are collecting them from year to year. Those who are there for the live event will get a red, white, or blue cookie. I'm not going to promise the red, white, or blue cookie to the Zoom readers because I'm assuming I'll be mailing these to you, and I don't predict that would turn out well. So The other thing for which you can get extra credit, the 6 o'clock series this fall of this semester is going to be completely with Zoom. And so those of you who have been around for a while know that on Constitution Day, we dredge up 4 of the authors of the Constitution to pick their brains about what they were thinking when they wrote the Constitution. And we have Benjamin Franklin, Alexander Hamilton, James Madison, and Charles Pinckney come, and we talk to them about the Constitutional Convention and the Constitution, and we ask them what they think of contemporary events. And so they're not doing 6 o'clock series in person, so this will be a Zoom event. But 2 of the founders will be with us at the reading of the Constitution, so you could come take a selfie with the founder, which, you know, that's always very cool. But you can also earn extra credit by joining us for the 6 o'clock series event from 6 to 7:30, and there will be questions and answers, so you can talk with the founder. There will be vouchers, because some other professors will probably be giving credit, and I don't know how they've worked that out, but they have somehow. So again, you can get credit for either one of these events, and I'll send out an email after I've finished after this class that has this information. Okay, so I'm curious, did any of you in throughout your school years, because this has been going on for what, 15 years now, did any of you were there any kind of events or anything to make you aware of Constitution Day coming up through school?
Not when I was in school.
No? Anybody else? So they are not doing their jobs. And, you know, it's interesting because I've been coordinating this since the beginning. And for the first time this year, I got an email from somebody who must be the compliance person saying, I heard that you do some of the Constitution Day things. Are you going to have them this year? You know, it's important that we have them, blah, blah, blah. I'm like, yeah, I know, I've been doing this. So anyway, I look forward to it, especially, you know, the t-shirts are cool. So, but those come with reading either in person or online. Okay, so today, quiz 2 is now available, and that's actually, we know what the website looks like. I meant to put it on PowerPoint. Where is my? Here we go. Okay. Oh, shoot. I wish I had an assistant to run this for me well. Yeah, well, okay, there we go. So last time we talked about what are referred to as the Civil War Amendments, and that's referring to the 13th, 14th, and 15th Amendments, and how the states got around the 13th and 15th Amendments. And just real quick, the 13th Amendment banned slavery, although there was a kind of a loophole in there, except as punishment for a crime. The 14th Amendment said that everybody was going to be a U.S. citizen who was born in the U.S. It said that all citizens, U.S. citizens, would have the same privileges and immunities as other U.S. citizens. It said that states would now have to provide equal protection and due process. And Section 5 said Congress would be able to enforce that. And then the 15th Amendment, ratified in 1870, said that states could not deny the right to vote because of race. So we talked about how the southern states got around the 13th Amendment because they used that loophole, except as punishment for a crime. And so there were, the black codes were drawn up, which were laws that used race either in the definition of what the crime was or in the sentencing part to make it more severe for blacks and whites. And that combined with convict leasing, and then also combination of sharecropping, which was the system of work that developed for the vast majority of African Americans in the South after slavery, where instead of being owned and working for an owner, they made deals to provide the labor while the plantation owner provided the land. And so but that ended up in a situation where always perpetually the amounts that crops were sold for didn't quite meet the debt that the African American sharecropper had built up by renting a house during that time, which were just houses, kind of a generous term. They were former slave quarters. And so that combined with something called a debt peonage law, which is a law that says you can't move if you owe someone money. Both of those combinations, debt peonage and sharecropping, as well as the black codes combined with convict leasing, meant that the South was finding pretty effective ways of limiting the freedom of African Americans. And then the South got around the 15th Amendment's promise that the states couldn't deny the right to vote using a variety of techniques, including grandfather clauses and poll taxes and reading tests and understanding tests. And then both of the South enforced both of these by the use of extra paramilitary terrorist groups, the Ku Klux Klan, to just terrorize the Black community into conforming with the social norms that the white community wanted to impose. And we also spoke about the very first case that involving the 14th Amendment, the Supreme Court's first stab at interpreting any part of the 14th Amendment. And it was their interpretation of the Privileges and Immunities Clause of the 14th Amendment. And that came in a case referred to as the Slaughterhouse cases in 1873. And basically the gist of it is the court says that, well, privileges and immunities come with your status as being a US citizen. It reaffirms what Dred Scott versus Sanford had said, that we all have two sets of citizenship. We have status as a US citizen and status as a state citizen. State citizenship comes with most of the rights that we have. Our privileges and immunities as US citizens is a pretty narrow list of things. So it defines privileges and immunities so narrowly that it doesn't really have a lot of benefit for the people it was designed to protect, the African Americans, because they said privileges and immunities of being a US citizen are those things directly related to the national government. So they said things like the right to move from state to state, the right to have access to the federal government within every county of a state, right to have access to an ambassador if you're traveling overseas. It's those kinds of things. So the point to remember is it almost creates a situation where the privileges and immunities clause just really means almost nothing after the Slaughterhouse decision. And then I have the administrative announcements are that Quiz 2 is now available, and I went ahead and it's going to be open through Sunday night at 11:30. There's a study guide for it. It's 10 questions and you have 12 minutes to complete it. it probably will take you about 3 or 4 minutes. So there's that. And then for today, we're going to start talking about something called the incorporation doctrine. We're going to focus first on the 14th Amendment's due process clause and how that played out. And then we'll go back and talk about the equal protection clause and how that played out. But first, for today, we're going to focus on the due process clause. So after the slaughterhouse, you know, one of the things we also talked about last time, there were some people that thought that the privileges and immunities clause meant that the Bill of Rights, the rights in the Bill of Rights would be applied to the states. But the court precluded that option. In fact, there were people that were on the committee that wrote the 14th Amendment, and not all of them, but some of them said, yeah, that's what we meant for it to do, to apply the rights in the Bill of Rights to be applied against the states. But that's not how the court went about it. So eventually, lawyers started looking for ways to use the due process clause of the 14th Amendment to apply some of the rights in the Bill of Rights to the states using the due process clause of the 14th Amendment. So this lecture today is the most difficult conceptually of all the ones we'll do all semester, but I'll repeat the main concept a bunch of times today, and we'll review it next time we meet. So hopefully, if the first time we go over, and we're going to go over something called substantive due process, which will make your eyes glaze over and probably make you want to shoot yourself in the head. And if you want to shoot yourself in the head, please keep your screen muted, your visual, because we don't need to see that. Just kidding. I mean, just kidding about you wanting to shoot yourself in the head. I was not kidding about we don't want to see that. Anyway, so if this seems real confusing the first time around, hang in there because hopefully it'll get a little bit better. Okay, so let's go back and so let's consider the due process clauses. As you know, there are two, because we've studied one of them in the 5th Amendment. No person shall be deprived of life, liberty, or property without due process of law. And we know from our study that that applied to the federal government. It wasn't applicable to the state governments. But then the 14th Amendment comes along, and because there was originally no mechanism in the Constitution that would allow the national government to intervene if states were systemically treating their citizens, denying them rights. There was nothing that the national government could do, at least not legally according to the Constitution. But the 14th Amendment provides a mechanism, because now it says, no state shall deprive any person of life, liberty, or property without due process of law. So now we need to, so we've got these two due process clauses. There comes to be two meanings of due process: procedural due process and substantive due process. And what we're going to talk about today is kind of the development of substantive due process and how that substantive due process is the mechanism by which the court eventually applies rights in the Bill of Rights to the states. So procedural due process was the original way that due process was understood. It was about how you do something. So the idea that when government impacts your life in a serious way, when government is denying you of property or your liberty or even your life, it's not that government can't do that. It's acknowledged by the very wording of the clause itself that government sometimes impact our lives in pretty serious ways. but that before the government does that, and as the government does that, there has to be a fair procedure in place. So it's not saying government can't deny you of life, liberty, or property, but simply the idea that it's got to have some sort of fair process. The process to which an individual person is due before government impacts your life in a really major way. Eventually, what's going to come is that some lawyers are going to talk the court eventually over a time of about 50 years into agreeing that there should be a more substantive notion. So whereas procedure refers to how you go about doing something, substantive due process refers to the actual what, the thing that you're actually doing. So eventually they're going to say, not only must when government is going to do some things to you, it has to go about a certain process. It's eventually going to come to mean that there are certain things that government just can't do without it amounting to denial of liberty. And it's the liberty in the due process clause that the substantive due process focuses on. So if we just abbreviate it to government's not going to deny liberty without due process. A procedural notion says, yeah, government's going to deny liberty all at once. It's just got to go through a process. Substantive due process says, you know what? There are certain things that if it's done, it's not liberty anymore in any true sense of the word, no matter how much process there are. And so there are certain things, because we're promised liberty, there are certain things that government just can't do. It's not liberty anymore. And no amount of procedures are going to fix that. And again, this will hopefully make a little more sense. So this is related to this incorporation doctrine. So broadly speaking, and there's three flavors of incorporation, which we'll talk about in a minute, but broadly speaking, the idea of incorporation is the idea that through a substantive interpretation of the Due Process Clause in the 14th Amendment, that parts, some or all of the Bill of Rights are incorporated or applied to be binding on the states as well as the national government. So let's, I already kind of said this, but in other words, no matter how fairly a state might try to do it, there are some things that a state just can't do without it amounting to a denial of liberty. So for example, with the right of free speech, eventually the courts are going to say, you know what, it just isn't liberty anymore if states are denying speech, no matter how much process there is to it. So there's, well, yeah, I guess I decided we'll just go with the two theories of incorporation. So the idea of total incorporation is that once you buy this idea that there is something called substantive due process, that's a real thing, total incorporation suggests that the first time that the court decides, yes, there's substantive due process, they would just import all of the protections in the Bill of Rights to the states all at once. That's not how the court went about it. They used something called selective incorporation, which is the theory that on a case-by-case basis, they would use substantive due process to say that some of the rights in the Bill of Rights should be applicable to both the states as well as the national government. And so eventually, within a couple of cases, it's clear that they're never going to do this total incorporation. They're always going to do it on a case-by-case basis. So the first time, we go through 50 years of lawyers asking the Supreme Court, hey, don't you want to, apply the Bill of Rights to the states, because due process and protecting liberty sometimes, there are certain things that if you do it, it's just not liberty anymore. And don't you want to do that to apply the Bill of Rights to the states? And the first time a majority of the court buys this argument is in Gitlow versus New York in 1925. And they, it's applied not the First Amendment, but the part of the first, not all of the First Amendment, but they said, did the free speech protection of the First Amendment apply to the states? And the court agreed with that. And I'm going to tell you, in a footnote, they said, yeah, we agree with you that the freedom of speech is so essential that it should apply to the states through the due process clause of the 14th Amendment. And the case itself is a little bit, it's kind of confusing because Benjamin Gitlow, the plaintiff in the case, loses the case, but yet they did win the victory of the free speech protection of the First Amendment now applies to the states. But that was because at the time the free speech clause was incorporated to apply to the states in 1925, the interpretation of it was just a lot weaker than it is now. So they said, yes, free speech should be binding on the states as well as the national government. However, this particular New York law, we don't think violates free speech, whether it's at the state level or the national level. So the facts of the case, so it's good for freedom overall, Gitlow versus New York, not so good for Benjamin Gitlow. So Benjamin Gitlow had been convicted of violating New York's anti-anarchy law for publishing some pamphlets and distributing them. And the pamphlets advocated socialism. And so eventually he was arrested and convicted. And so the court said that eventually, yeah, you're right, your lawyers are right. New York should have to protect free speech as well. However, the standard interpretation of the First Amendment's free speech clause at the time was that they judged it by the gravity of the evil. In other words, free speech was protected unless what was being advocated for by speech was so evil that they said things that were really evil, when you advocate for that, that wasn't protected by the First Amendment. That's no longer the interpretation. There's a lot more robust protection of speech, but that explains why he was still convicted, even though the 14th Amendment had been amended. And so why did it say my slideshow was over when there are more slides? Okay. Let me reshare. Well, you know, this computer is not what it used to be. So hopefully, okay. So eventually, this is what we mean by selective incorporation. On a case-by-case basis, over a number of years, and this is a 2-page list, the rights, and you're not responsible for these. This is merely an illustration to show you that on a case-by-case basis, little bits of the Bill of Rights eventually were incorporated to apply to the states. And almost all of them have been applied, but it's selective incorporation because it was never like a whole thing all at once. And there are still parts of the Bill of Rights that haven't been incorporated, although I need to update this slide because the Third Amendment has never been incorporated, and that actually probably won't ever change because it really doesn't lend itself to it. The grand jury provision of the Fifth Amendment has never been incorporated because the courts have said it would probably be too prohibitive to apply to the states. You know, the grand jury provision, remember, says that a prosecutor can't charge someone with a capital or a really serious crime without using a grand jury to charge. And, you know, there are relatively few capital or serious crimes at the federal level as opposed to the state level, because states are the level of government. You know, 90% of all cases, civil and criminal, take place in state courts. So that has never been incorporated. The Seventh Amendment, jury in a civil case, hasn't been incorporated. I don't think that will be. And then the Eighth Amendment, you know, there's two parts of the Eighth Amendment, the no cruel or unusual punishment and the no excessive fines and bails. I actually need to change that because in June, that became incorporated. And I always thought that that would be the next part to finally be incorporated, applied to the states. So I'll get rid of that. But you're not being tested on that. You might be tested on, is all of the Bill of, has every provision in the Bill of Rights been applied to the states? And the answer is no. But whether it's 3 or 4 parts, I'm not going to be that specific. Okay, so we've got this selective incorporation doctrine. Let's go back to 1925. They've just decided, yes, substantive due process is a real thing. There are some things that are just so inherent in liberty that to deny them, it's not liberty anymore. But that implies if they're only going to incorporate parts of the Bill of Rights and not just the whole thing, then there has to be a principled way for the court to make that decision. You know, the court's not going to just say, oh, this one feels like it ought to be applied, this one doesn't. You know, courts have to come up with a rationale that they can articulate to explain why they, incorporated, the First Amendment, but not the grand jury provision, or why they incorporated the no unreasonable search and seizure provision, but not the provision about jury trials in civil cases. And so if you say which rights in the Bill of Rights are you going to apply to the states, the court answers that as fundamental rights. But it also answers the question of, okay, but how would I know a fundamental right when I see it? And there's 2 questions that the courts ask to determine if a right is a fundamental right. And the first question is the right in question so deeply rooted in it, really deeply rooted in the history and tradition of US law and society? In other words, have we just always, and maybe even going back to the British law, not always, but sometimes they do focus even on that, but they say it has, and the reason they're asking this question is that's one way of figuring out what's a really important right. Well, since the beginning, we said this is a really important right. The second question they ask to see if something is a fundamental right is that it must be so important that you can't imagine a free society without it. And the case that the Supreme Court finally articulates what is and isn't a fundamental right in a clear way, because at first, sometimes they were saying, they were focusing on the deeply rooted in history and tradition, but then sometimes they would emphasize more that the right is so important you can't imagine a free society without it. And finally, in 1938, about midway through the incorporation process, on the 1938, partway into the incorporation process in terms of years, the court says, you know what, let's articulate this a little more clearly. And so they kind of clarified what were fundamental rights. I said 1938, 1937, and said it's stuff that's really deeply rooted in history and tradition, and the right in question is so important you can't imagine a free society without it. Now, if you were to read Halco words the second question a little bit differently, but for a long time, I just couldn't really get my head around the way the court had worded it. They said, for point number 2, that the right in question inheres in a concept of ordered liberty. And I always had trouble with that. I think I know what it means now, but so when I finally figured out what I think is an easier way of grasping it, I say that really it's just so important that you can't imagine a free society without this right. In other words, that's not a society of liberty. And so, you know, if you say free speech, yeah, you really can't imagine a society that doesn't have this. Now, let me just check something real quick. Okay, so the way that they chose to do this, in other words, using it rather than total incorporation, they went to selective incorporation, why they had to come up with the way of analyzing it. You know, if they had just, with that first case in Gitlow versus New York, if they had just said, you know what, there is a substantive meaning of due process. There are certain things that government just can't do and call it liberty. And that includes all of the Bill of Rights. Then they wouldn't have had to come up with this 2-part test of, you know, which rights are they going to incorporate? Because when they incorporate some and not others, it was stating, well, which rights are we going to incorporate? The fundamental ones. And so it is kind of making a distinction between the rights and the Bill of Rights. But the other thing that test sets up is combined with the 9th Amendment, which says that the rights that we are aware of, combined that the rights in the Bill of Rights aren't all the rights that we have. That combined with this 2-part fundamental rights test has been now used to help the court decide which unenumerated rights are constitutionally protected. And that almost sounds like an oxymoron to say that unenumerated rights are protected by the Constitution. You know, you're saying that rights that aren't in the Constitution are protected by the Constitution. It almost sounds like an oxymoron, but that's essentially what the 9th Amendment is saying. And so that's the test that the court uses. So the right that the court used this to find the right was in a case called Griswold versus Connecticut, the right of privacy. Because the right of privacy, it's interesting because for many years when Americans have been asked about what are the most important rights, privacy makes the top 3 and has been ever since they've been asking the question for about 40 years. And yet, privacy isn't mentioned in the Bill of Rights or anywhere else in the Constitution. But in 1965, the court, quote, found a right of privacy in the Constitution. So I'd like to talk about, well, actually, I think I'm just going to hammer home for a few minutes the whole substantive due process incorporation thing, because this really is the most confusing part of the class. If you get this part, you're going to get the rest of the class, no problem. So again, all that it's saying, you know, we come up with this system of government where You have the national government and the state governments. And the fact that they add this Bill of Rights to the federal constitution, and it only applies to the national government. But eventually, because there was this problem in the creation of the Constitution, remember, they never assumed that it was going to be states that wanted to violate people's rights. And so there wasn't a way for the national government to protect people. And so a substantive interpretation of the Due Process Clause of the 14th Amendment is eventually what's used to accomplish that. And in fact, the other day when I showed the PowerPoint where we show government as the monster and stuff, I had lost the PowerPoint because I clicked the wrong thing, but I think I've sort of recreated it. And I want to show you what difference the 14th Amendment and due process makes in that picture. So, sorry. No. That's fine. Okay. So we talked about how, and I'll just go through that. So, you know, we as Americans, we know we have rights, but we don't have a good understanding of what those rights are or who or what we're being protected from. So we talked about, okay, so what is it that can burden your liberty? Because it's those entities that we're being protected from. Rights are a legal mechanism to force government to recognize certain rights that people have. And in our system, it's not just rights articulated by the Constitution, but it's rights that are inherently ours because we subscribe, you know, the guys who wrote the Constitution and the legal system subscribes to a theory of natural rights, meaning that rights aren't given to us by government. We have them inherently just by virtue of being born, and it's government's job to protect them, whether or not they're articulated in the Bill of Rights. So one of the entities that can burden your liberty is the federal government. Another one is the states. You know, society can also burden our liberty. And so I tried to make the case that if we think of the Bill of Rights as a shield of rights, the way it was originally done was that it was a protection only against the national government. And so let me do something. Is that? Let me see if this is going to work. Okay, so it's going to work. Okay, so if that's the case, then we can think of, if we think of the 14th Amendment, specifically a substantive notion of due process, that's eventually a shield. And notice we hold the shield against the federal government, but against the states, it's the federal government promising and incorporating those rights against the state for us. So by the time, you know, we finish up with this process of selective due process, we're promised most of the things in the Bill of Rights as protections against the state as well as against the federal government. And what the Equal Protection Clause is going to eventually do is make it so that we're also protected, the federal government is also protecting us from members, you know, from groups in society that would deny us certain rights. So That's kind of how that process worked. So we went from this more limited notion of liberty into a more robust one. But once, and especially once we get to government protecting us against society, that's where we start calling it civil rights instead of civil liberties, because government actually has to do something for the rights to actually become a reality. Okay. Does anybody have any questions about that? And this is one that a lot of students come out of their con law class in law school and are not real sure about the substantive due process thing. That's awesome. You're either, it either means I'm totally effective and you're really smart, or you're asleep. Either one of those will work. So because we got through substantive due process, I'm gonna say that that's a class time. And we will call it a day. Cool. All right. Don't forget the quiz 2 is online. Thank you, Christine. And I will see you guys next Tuesday. But I'm going to send out the thing about the extra credit on Constitution Day.
Have a good day.
You too. Thank you.
Thank you.
Thank you.